My name is Richard Wilner. I'm a co-founder of the law firm of Wilner and O'Reilly. I have been practicing immigration law exclusively since 1999. I've been board certified as a specialist by the State Bar of California, Bureau of Legal Specialization for over 2 decades. The goal of this podcast is to provide you with valuable information. Today, we are going to talk about the TN visa as well as E-3 visas. Both require nationality in specific countries. In previous episodes, we talked about the H-1B, which has a lottery process and a finite amount of visas available per year. The TN and the E-3 don't have those same numerical limitations. As mentioned, however, you have to be a national of a certain country. TN visas require you to be a national of either Canada or Mexico, and depending upon where you come from, the process can change. E-3s, on the contrary, require you to be a national of Australia. What do these visas have in common? The primary commonality in these types of visas, and like the H-1B, these visas have to be, or the position that you're working in has to be a specialty occupation. And in plain English, specialty occupation means a bachelor's degree or higher is required to perform the duties associated with the position. We don't make up, you don't make up which positions require a bachelor's degree. Instead, the Department of Labor from the United States government has already decided that for us. When it comes to TNs, the TN visa, which stands for Trade NAFTA, even though NAFTA is no longer called NAFTA, the visa is still called the TN. And the TN visa, in order to be working as a TN employee, the position at issue has to be listed on what's called Schedule 2 of NAFTA, or today's treaty, the USMCA. As long as the position is listed on Schedule 2 of NAFTA, and you have the requisite qualifications and a U.S. employer, you are eligible to pursue a TN. If you are Canadian and outside of the United States, you're not required to file anything in the United States beforehand. Instead, this application could be processed in its entirety at the port of entry. If you are, as a Canadian, already here, or as a Mexican national already here in the United States and do not wish to leave, so long as you are maintaining your lawful non-immigrant status, you can file a change of status from that existing status to TN. For example, if you're here as a visitor and you are within your permitted period of stay and otherwise qualified for the TN status or visa, you can file that application here in the United States and change your status. If approved and you ultimately leave the United States, prior to coming back to the U.S., you will need to, if a Mexican national, you will need to get a visa label in your passport. Those visa labels are done at U.S. consulates overseas, so a U.S. consulate in Mexico, and you will need that visa label in your passport prior to returning to the United States. If you're a Canadian national, however, as mentioned previously, you do not need to go to U.S. consulates because you are considered to be visa-exempt. So if here in the United States and you change status and leave to Canada or elsewhere, when you return to the United States, you would need to present a detailed packet of information to the officer at the port of entry. Those officers are from United States Customs and Border Protection. You would present that packet to them and then be admitted into the United States in TN status. TNs, unlike other types of visas, do not allow for what's called dual intent. It is a non-immigrant visa. A non-immigrant means that you intend to return to your home country when you're done doing the work that you intend to do here in the United States. Schedule 2 of NAFTA is very specific as to which positions are allowed for TN visas. Because they are very specific, many people try to qualify as management consultants. It's the most abused category there is, and naturally the most scrutinized category there is. So unless you are a management consultant by trade, in my opinion, it's not going to work. Nor should you try to claim to be a management consultant, obviously, unless you are one. Let's switch to E-3s for a minute. E-3s, as previously mentioned, are for nationals of Australia. Still has to be a specialty occupation. Specialty occupation means bachelor's degree, and you would be working in that position. E3s can be self-employed. For example, you could own the corporation that is petitioning you for the E3. What's key is, again, and I can't emphasize it enough, specialty occupation, bachelor's degree. Sometimes our friends from Australia obtain bachelor's degrees in 3 years as opposed to the normal 4-year program in the United States. That can be tricky and is highly scrutinized. So if we're talking 3-year bachelor's degrees from Australia, we often will get those degrees evaluated plus work experience, which is done by an independent evaluation company, but it's simplest if it's a 4-year degree or if you have an advanced degree such as a master's degree or higher. These situations are very nuanced and fact-specific, and obviously I can't provide you all the information necessary today, but I hope you were able to gather something that's valuable to your future. If you are in need of further information, please don't hesitate to contact me personally or our firm in general. As mentioned, the firm is Wilner & O'Reilly. Our website is wilneroreilly.com. We look forward to hearing from you, and we're here to serve.